Good afternoon. Thank you for joining this session, which will deal with recent developments on class actions in certain countries. The first two speakers will address European countries, and I assume they will refer to the recommendation published in June 2013, as Professor Hodges reminded in the last session, on the common principles for injunctive and compensatory collective redress mechanisms in member states. It will be very interesting to hear how and to what extent the member states in the European community have applied those principles or not. The first speaker will be Professor Stefan Voet from Belgium. Professor Voet was originally supposed to address two countries, two jurisdictions, Belgium and France. However, 2 days ago, we were advised that another professor that was intended to speak this afternoon, Professor Van Boom from Holland, would not be able to participate. Fortunately, Professor Stefan Voet is very well acquainted with the Dutch system and agreed to add to his lecture a review of the recent developments in Holland. And we thank him for this. Professor Voet is an associate professor at the University of Leuven and a host professor at the University of Hasselt, both in Belgium. Stefan teaches national, European, and international civil procedure. His main research interests are complex litigation, ADR, ODR, dispute resolution design, and litigation costs. He was also a member of different governmental working groups on class actions and mass disasters. And here comes the interesting part. Stefan is also a freelance opera critic. So I invite Stefan. You have a choice. You can either recommend the best opera performances in Europe this year, or talk on class actions, please.
Good afternoon, ladies and gentlemen. I will not talk about opera, although I saw a very good performance of Armida last week of Rossini, but that is for another audience. Now, first of all, I'm very happy to be here, to be back in Israel. I was here in 2013, so I'm very glad to be back. And again, I would like to thank Ariel and Rabia for the wonderful organization of this great conference and for the invitation. Now, I was originally asked to tell you something about the situation, the developments in Belgium and in France, two countries that have been in the news the last couple of weeks for other more disturbing reasons. So I will start my presentation by talking about those two countries. And then after that, so you will have to listen to me, unfortunately, for 40 minutes, I will say something about the Netherlands. Now, unfortunately, I do not have slides about the Netherlands. I just scribbled down some words, some sentences on the plane yesterday. So you will have to do it without a presentation. Now, first of all, Belgium and France. Now, practically at the same time, but independently from each other, Belgium and France adopted a consumer class action regime. Now, it was not the first proposal that was made. Before that, different proposals were launched. I think in France, there were between 2005 and 2015, I think there were no less than 16 proposals. But all these proposals didn't make it because a political consensus could not be reached. In 2013, 2014, that was possible, so both countries adopted in March 2014 a class action procedure, and both procedures, and that's important to underline, are embedded in a broader legislative reform. It's not an act as such, but it is embedded in a broader context. In France, the Class Action Act is laid down in the Loi Hamon, which is the new Consumers Act. The class action chapter entered into force on the 1st of October 2014, and when you look at it, you will see it's a very concise act. There are only 26 brief articles regulating the procedure. In other words, the French rules are not very detailed. What they offer is a broad framework, and a lot of leeway, a lot of powers are given to the court that can steer the procedure. There's an article, a very small article in the Act, stating that the judge, the court, can order whatever he wants to order. Also regarding discovery, regarding evidence. So I think, and it is said in literature, that this will be the key provision of that French Act. In Belgium, the new class action is embedded in the new Code of Economic Law that codifies all economic legislation in Belgium in the most broadest sense of the word. And the Class Action Act there entered into force on the 1st of September 2014. And then when you look at the act, it's very detailed. 34 articles regulating everything. So less leeway, less powers are given to the court. So it's a completely different approach. Now, from the beginning, I think it is important, and it refers to what Chris said this morning, it is important to underline that the mindset in France and Belgium and Europe in general is different from the American one. In the US, the focus has been on private enforcement, class actions, not only as a compensation mechanism, but also as a regulatory enforcement mechanism, the concept, the idea of private attorney generals. In Europe, for historical reasons, the division between public and private enforcement has been stronger, and this remains so in the class action debate. The EC recommendation that Chris mentioned this morning and its surrounding policy documents emphasize that class actions supplement public enforcement. However, the empirical question that is not answered, and that Chris and I are trying to answer, the empirical question that is not answered is how much public and private enforcement is actually going on the ground, and does private enforcement really supplement public enforcement? A concretization of this idea are the so-called collective follow-on actions. In fields of law where a public authority is empowered to adopt a decision that there has been a law violation, then collective redress actions, group actions, can only start after this public process. The idea behind it is that the public interest and the need to avoid abusive litigation can be presumed to have been taken into account by that public authority. And a beautiful example you can find in France. France has consumer class actions, but also allows class actions in competition cases, but they are exclusively follow-on actions. So they are authorized only when there is a final decision of the national authority, the National Competition Authority, the European Commission, or a court. And that decision is an irrebuttable presumption from which the court cannot depart. So if a class action is brought in that case, then there will be no discussion about liability. The only issues that will rise will be the determination of the class, the damages, and the publicity process. Now, the underlying policy in the French, and especially the Belgian legislator, is that consumers, you can have a class action, but we actually want you to settle those mass disputes out of court. And consequently, a lot of attention is paid to the out-of-court resolution of mass harms. The Belgian law is impregnated by that idea. Just like the Dutch Collective Settlements Act, and I will talk about the Dutch Collective Settlements Act in a moment, it is possible, contrary to what is happening here in Israel and the discussions we had this morning, it is possible to have a prior collective settlement approved by the court. Now, I want to emphasize that that is not a pro forma approval. The judge will not just stamp that settlement and say it's okay. No, the court will look into the details of the settlement. And if, for example, the damages awarded to the class are unreasonable, then the judge will say, or the court will say, you have to amend the settlement, or I will not approve the settlement. In case no settlement is reached, then you can initiate a procedure. There's first of all a certification phase, And when the class action is certified, then there is a mandatory negotiation phase. So the plaintiff and the defendant have to sit around the table and they have to try and reach a settlement. They have a minimum period of 3 months, maximum 6 months to do so. If they reach a settlement, hooray, then again the court can approve the settlement. If there is no settlement, then the court will render a decision on the merits of the case. But even in that last phase, the merits phase, parties can always agree a settlement. It's also possible that the parties can ask the judge to appoint a mediator to help them to reach a settlement. In the Dutch system, those tools to help the parties to reach a settlement have been expanded recently, but I will come back to that in a moment. The French Act contains a similar provision. Collective settlements have to be approved by the court. Now, every class action has a bunch of building blocks. Now, because of time limits, I cannot talk about all of them. I will discuss 3: scope, standing, and the discussion opt-in versus opt-out. Neither the French nor the Belgian class action regime is of a transubstantive universal nature, in the sense that it applies to all fields of law, contrary to other countries like in the Netherlands, the US, Israel, although I had the impression that in Israel that's not the case. The French law only applies to consumer law violations, violations regarding the sale of goods or provision of services, and as I already mentioned, competition cases, competition law violations, but only as follow-on actions. In Belgium, there's a certification phase. In French, there's no formal certification phase. And the first class action prerequisite in the Belgian class action certification phase is that the cause of action must be a possible infraction by the defendant on his contractual obligations or on one of the 31 European or Belgian consumer regulations or acts that are enumerated in the act. So the act contains a list of all statutes, regulations, and you have to pick 1, 2, 3, 5 of them to have your cause of action. All these regulations deal with consumer law, so they only apply to consumer law violations. There was some debate to extend it to shareholder disputes, but that was rejected. So for shareholder disputes, you cannot use the class action procedure, although I found that there's one provision where you can use the class action for cases of mis-selling, so I think that'll be possible. Now, there was some debate about the question whether this limited scope of application puts the access to justice principle at risk. Because for consumer disputes, small disputes, you now have a collective access to justice, but victims of mass accidents or security cases who fall outside of the scope of the law only have individualized access to justice. Maybe I know a little bit of the jurisprudence of the Belgian Constitutional Court. Maybe they will have a problem with that. In France, they have a very bizarre judicial review mechanism. A lot of things in France are sometimes very bizarre. There's a Conseil constitutionnel, a constitutional council. There's no full constitutional court. The members of that constitutional council are the former presidents. They don't know anything about constitutional law, and they did not have any problem with that issue. Contrary to the US, where standing is given to an individual class member, the French and Belgian class action can only be initiated by what is called an organizational, associational, or ideological plaintiff. There is an association as having no personal cause of action, personal interest in the outcome of the litigation. Only accredited, so they have to be approved by the government, accredited consumer organizations have standing in Belgium and France. In France, there are about 16. In Belgium, there are about 30. But in theory, in practice, there will only be one. One is big enough to bring those cases. Now, in Paris, in France, that led to a debate. There was a counterattack by the Paris bar that said you could not only give that to associations, we, lawyers, should have the opportunity to bring a class action on behalf of an individual class member. Now, as a sort of counterattack, they launched a bunch of websites where they solicit clients that are people that are the victim of a mass harm. For example, now there's the Volkswagen case. Well, the Paris bar has set up a very fancy website where you can click on and where you can register. I think you have to pay 500 euros, and then a lawyer of the Paris bar will bring that case. So, I mean, the Paris bar was not very happy with that idea. In Belgium, and that's quite important, standing is also given to a public body, namely the new Consumer Mediation Service. I don't know, we had in Europe the 2013 ADR directive. Well, that directive basically says that you have to have an ADR entity, an ADR body in all sectors. If you don't have one, then you can create a residual ADR entity. Well, that's Belgium's residual ADR entity, that Consumer Mediation Service. They can bring a class action, but they can only negotiate a settlement. If there is no settlement, then they have to step out, and then a consumer organization has to take over. Opt-in, opt-out. Now, the EC recommendation, as Chris mentioned, puts forward the opt-in system as the default. However, it leaves an opening for opt-out class actions. Opt-out is possible, and this is what you can read in the recommendation, if this is justified by reasons or sound administration of justice, whatever that means. Now, an important decision in Europe regarding opt-out class actions is the Dexia decision, the Dutch Dexia decision of the Amsterdam Court of Appeals, where one of the parties, one of the objectors, said, well, opt-out class actions violate Article 6 of the European Convention of Human Rights. The court looked at US case law and they said, no, opt-out class actions do not violate Article 6 of the European Convention of Human Rights, due process, as long as there is notice and as long as you have the possibility to be heard and have the possibility to opt out. The French system is formally an opt-in system, but some have said that it is what is called a de facto opt-out system. In the sense, and I will come back to that in a moment, the French court will first issue a decision on the liability of the defendant. The class members are not involved in that procedure. When the court, establishes the liability of the defendant, then that decision is published, and then the group members, the class members, members that meet the criteria as set out by the judge, can opt in the procedure and can say, we want to have money. So the moment where the class members have to opt in, at that time, they already know that they're going to get something, how much they're going to get. And if they don't like that outcome, then they can simply not opt in. But the opt-in is done after the court has issued a decision on the liability issues. In Belgium, that's completely different. In Belgium, there's a certification decision, and at the end of that certification decision, the judge will choose between an opt-in or an opt-out system. The same exists in some Scandinavian countries, where the court can choose. In some cases, the court must impose an opt-in system when physical or moral damages are claimed, or regarding class members who are not residing in Belgium. We copied that from the class action system in some Canadian provinces. Now here the consumer has to opt in or opt out after the certification decision. And the choice that that consumer makes is irreversible. If a consumer has opted in or has not opted out, and afterwards disagrees with a collective settlement or disagrees with the decision on the merits of the case, tant pis. The consumer will be bound by the res judicata effect of that settlement or decision. And the philosophy is that the Belgian legislator wants to avoid that class members, contrary to France, make their opt-in, opt-out decision in function of the result of the procedure. I do not think that it's a wise decision because it could lead to the fact that a lot of class members will simply not opt in or opt out because they don't know what will come. They do not know what the outcome of the procedure will be. So I think it's a pity that the Belgian Act does not give the possibility for the judge, discretionary possibility for the judge, to organize a second opt-in or opt-out round after a collective settlement or after a decision on the merits of the case. The French procedure, as already mentioned, consists of 2-3 phases. There's no formal certification phase. So in the first phase, the association brings a series of test cases to the court. And then the court will establish or will decide if the corporation, the defendant, is liable or not. If liability is established, then the court will shape the class action, the criteria that class members must meet to be included in the group, the damages to be awarded, etc. That decision does not have a res judicata effect for the class members. No, then there's the second phase, the compensation phase. That decision is published. There's no individual notice, just published in the newspaper and I think on a website. And then people who think that they are eligible for compensation, then they can opt in. So they can only opt in once that decision, that liability decision, is final. So also when, that will also only happen when the period to appeal that decision has stopped, has passed, so that the decision cannot be appealed anymore. In Belgium, there's first of all a certification phase. There are 3 certification criteria. 1, it has to be a consumer case. 2, there has to be an adequate association. So it's not enough that there's a consumer association. That association also has to be adequate. And finally, there is a superiority requirement. The class action has to be more suitable than an individual civil action. Then there's a mandatory negotiation phase. If no negotiation settlement can be reached, then there's a decision on the merits of the case. And at the end of the procedure, and I think we looked at other systems that have that, there's an enforcement phase. And during that enforcement phase, the court will appoint a collective claims settler, a sort of special master, who will be in charge of distributing the funds among the class members. So the courts said, well, we will not deal with that. That has to be done by somebody outside of the court, somebody that we will appoint, a sort of expert. If problems arise during that phase, they can always come back to the court. Now, how many cases were brought? Well, in France, the act entered into force on the 1st of October 2014, and to date 5 cases has been brought. They are all French cases without an international aspect. 2 cases deal with undue fees paid by tenants. The first case, which was brought the first day that the act entered into force, the 1st of October 2014, was an easy case in the sense that there the defendant already had been fined by a criminal court, I think in Nanterre, for comparable practices. So the liability there was not an issue. The second case, which was about a class of 100,000 class members, was quite quickly settled. That was a 2 million euros settlement. Details of that settlement were not disclosed. Other cases deal with breach of contractual obligations, unfair contract terms in property lease contracts, and misleading information by a telephone company on its 4G internet coverage. In Belgium, there's 1 case that is filed with the court, Testachat, so that big consumer association, against Thomas Cook, which is a tour operator. It's quite a funny case. It was about a flight from Thomas Cook from Tenerife to Brussels. Everybody was on the plane was supposed to leave, but then suddenly I think somebody drank too much sangrias. He drove with a mobile escalator. He collided with the plane. The plane was damaged, so everybody had to get off the plane, and they had to wait for 8 hours before there was a new plane. Thomas Cook said, Aircraft, we're not going to pay anything. Testankoop said, you have to pay 400 euros per passenger, so they brought that class action. It's not a very interesting one, but at least there's one. In Belgium, there will be an evaluation of the act in 2017. In France, and Chris already mentioned that, in France they're not going to wait to evaluate the act. There are 2 very concrete proposals to expand that class action regime, as I discussed previously, for consumer cases, to discriminatory practices and to health-related claims. The health or the medical class action will probably not work. I tried to read it. It's very complicated. And the problem there is that if the court establishes liability, there is a period, I think, of 5 years during which class members can opt in. So I think that's a bit crazy. There was also a proposal to have a class action in environmental cases, but the Assemblée Nationale, the National Assembly, didn't, there was not a majority there to do that. Moreover, there's also, and that proposal was approved by the Senate on the 5th of November 2015, there's a proposal to create a generic class action for all civil courts and also for all administrative courts. Now that proposal has gone to the National Assembly, and there will probably be a debate there now. Now, will these class actions work? Now, first of all, we'll have to wait and see how many cases will be brought, what the outcome of these cases are. But I do think that there is a fundamental problem, the fundamental problems that I think they're different bottlenecks. The first one has to do with funding and financing these things. The Belgian and the French legislator assume naively that the funding rules on one-on-one litigation will simply apply to those class action procedures. So bringing those procedures will come down to the financial willingness of those associations. Now, those associations, they have some funds, but they don't really have a lot of funds. So I think that there will be no incentives to bring those cases. We also have a loser pays rule. So if the association loses the case, then they will also have to pay the costs of the defendant. And then I think there will be a real disincentive to bring class actions. There are also some procedural reasons. And in Belgium, you can see on the slide, l'effet dévolutif élargi de l'appel. I'm very sorry it's in French, but I have no idea how to translate that in English. But it boils down to this. There's a certification decision that is rendered by a first-instance court. Now, that certification decision can be appealed. Now, there is a doctrine in Belgian, French, also Dutch law, saying that if a decision is appealed, then all the legal and factual issues that have not been decided by the first instance judge go to the appellate court and stay there. So if, for example, the appellate court affirms the certification decision, then the case does not go back to the first instance court. In other countries, in the US, that's, for example, the case. No, the case stays with the appellate court, and they will deal with the approval of a collective settlement. They will deal with a decision on the merits of the case. So the class action procedure for the first instance courts will be like a boxing game, will be the first round. Because the stakes in these cases are very high, and I think that whether the class action is certified or not, there will always be an appeal by the defendant or by the plaintiff. So the case will always go to the court of appeal. The backlog in the courts of appeal, the Court of Appeal in Brussels, because they have exclusive competence, is enormous. For an individual case, it now takes 4 or 5 years to have an individual case be decided. I think for class action cases, it will be 10 years or something like that. So that is, I think, a major issue. In France, I think maybe the same problem will arise because I read in the law that the liability decision also can be appealed, and they have that same concept. What is more important is that recently, and now I'm giving Belgium as an example, there are other techniques, other ways that can offer redress for consumers maybe more quickly, more efficiently, and with less intermediary costs. Belgium, for example, has 2 unique portals, online portals for consumers. In implementing the ADR directive, the Consumer Mediation Service was created, and they created a website where consumers, if they have a problem with a trader, then they can simply go to that website, fill out their problem, fill out a complaint form, and then the Consumer Mediation Service will see if there is an ADR entity that is competent to deal with their dispute, and they will simply refer the case or if there is no competent ADR entity, they will deal with the case themselves. So in that capacity, it serves as a residual ADR entity. Attention has also been paid to ODR, online dispute resolution in Belgium. 2011, the Belgian Ministry of Economic Affairs launched BelMed, which is an abbreviation for Belgian mediation. And it's a digital portal, a digital platform for ADR and ODR, which it wants to promote and make more accessible. BelMed consists of two pillars, offering information, and on the other hand, again, you can make a complaint through that portal, and then the complaint will be sent to a competent ADR body, and they will resolve the complaint very quickly, very efficiently, sometimes at no costs, and everything happens online. Now, the most important point of critique, my most important point of critique, is the lack of integration of all these dispute resolution avenues. I think it's okay to have ADR. It's okay to create an ODR platform. It's okay to focus on public enforcement, but the crux of all of this is to link these systems in order to create an integrated and efficient dispute resolution framework. For example, an ODR platform, and I'm quite familiar with the Belgian ODR platform, has a lot of data, a lot of statistical information. They can perfectly see if there is a major problem with a specific trader or with a specific product. They can see that because a lot of applications are being made. Well, that information can be anonymized, and it would be perfect, I think, to transfer that information, for example, to a regulator who can act very quickly, very efficiently, and if there has to be a sort of compensation for the duped consumers, then there could be a referral to an ADR body that works together with the regulator to offer redress, restitution for the consumers. Maybe, I think, that is a much quicker and much more efficient solution than those class action procedures. But we will have to wait and see what the future brings. This, ladies and gentlemen, what regards Belgium and France. I will now first have a sip of water. Okay, part 2. The Netherlands. Now, I just scribbled down some things on the plane yesterday. I hope I can read them. But basically, in the Netherlands, there are two collective redress regimes. The first one was created in 1994, and it is called the collective action. The second one, and both are important because they are linked to each other. The second one is the famous WCAM, the WCAM in Dutch, the Dutch collective settlement procedure that was created in 2005. Now, both regimes are of a universal transubstantive nature. They apply in all fields of law. First of all, the collective action, Article 3, 305A of the Dutch Civil Code, created in 1994. Now, the focus of that collective action is on the protection of similar interests of individuals. The criterion is that there have to be similar or equivalent claims. In Dutch, there's a beautiful word for that. There's, I think, only one person in the audience that speaks Dutch. It's called bundelbaarheid. It's the degree to bundle claims. I think that's a fantastic word. So it has to be possible to make a sort of abstraction out of those individual claims. And then you can bring that collective action. Only associations can bring that collective action. The statutory aim of the association must overlap with these interests. So they have to be what are called representative organizations. So they have to be representative enough. That's a second aspect that the court will take into account. There's no certification phase, but the association, that's the third requirement, the association has to show that they have tried to reach a settlement with the defendant. Only then they can bring that collective action. Now, essential is that collective action can only be used to obtain injunctive or declaratory relief. In 1994, the Dutch legislator said, we will not allow damages. So you cannot use that collective action device to claim monetary relief, to claim compensation. Keep that in mind. I will come back to that in a second. Now, the association brings the collective action. The court will render a decision. The class members, between brackets, because it's not really a representative action, are not bound by that decision. They are not bound by the res judicata effect of that decision. There is, and there's a Supreme Court decision of the Netherlands, I think of 1998 or something, VEB against World Online, that said, well, it's not res judicata, but it's de facto res judicata. Because the individual consumer victim can use that decision to claim compensation, and the judge who deals with that, well, the Supreme Court said that it has to be a very stupid judge if he renders a different decision. So in 99% of the cases, he will simply follow that. Some examples, I think 20, 30 of these cases are being brought in the Netherlands per year. One famous case had to do with the trade fair. There was a big trade fair, and there was a hot tube in the trade fair, and the Legionella bacteria was in that water. So everybody was walking around, went home, everybody got sick. An association brought a collective action, and I don't know, the person or the company that organized the trade fair was held liable. Some individual cases were brought, but the company said, well, everybody who can prove that he was there and everybody that can prove he was sick will get a sort of compensation. Another more recent case dates from 2013. Also a collective action. It was in the media, I think, a couple of years ago. It was a Dutch association that acted on behalf of some individuals in Nigeria. Shell, Shell, the big oil company, has some plants in Nigeria, and those people said that Shell was liable for oil spills in Nigeria. There was some debate whether that collective action could be brought, but the court in The Hague, I think it was, said yes, that is a collective action that is admissible. And now the court also said that Shell is liable, and now those individuals will probably sue Shell to claim a sort of compensation. Also, cases regarding equality law. For example, there was a recent case where a women's association brought a collective action against a Christian political party, because that Christian political party said that women cannot be elected. And that women's association said, no, you cannot do that. The argument of that Christian political party said, well, these women who are members of our party, they don't want to be elected. The court said, we don't care, it's still a discrimination. And they sued the state because the state subsidized that Christian party, and that party had to change its policy. Now, the last word about that collective action has to do with the fact that I said that to date, it is not possible to claim money, to claim compensation. In the last sentence of that article, it says, with the exclusion of damages. There is now a proposal pending in the Netherlands to erase that sentence. It's called the motion Dijksma. Dijksma is the guy who made that proposal. And if that would happen, then you would have a sort of class action system in the Netherlands that would also allow to claim for compensation. Now the current government in the Netherlands said no. They put the proposal in the fridge, but now I have the impression that they will probably put the proposal outside of the fridge because there are a lot of conferences that are being organized in January and in February in the Netherlands about that proposal. So we will have to wait and see what will happen with that. Now, to date, it is not possible to use that collective action for damages. So to supplement that problem, they created the famous WCAM procedure, WCAM, the Dutch Collective Settlements Act. What is the origin of that thing? Well, the origin is one specific case, two things. One specific case, which is the DES case. I don't know, most people are probably familiar with that case, but DES was a hormone that was given to pregnant women in the 60s and the 70s. The daughters that were born had a lot of medical problems, so there was a problem with that medicine. A lot of women, the DES daughters, sued the pharmaceutical companies. There was a lot of litigation. And at one point, there was an association defending the interests of all these victims, and they had a victory at the Supreme Court in the Netherlands. At one point, the Supreme Court said in very general terms that the pharmaceutical companies are liable for the damages that that hormone caused. Now, at that point, you had hundreds of individual procedures, and those pharmaceutical companies said, look, we are not going to litigate all those individual procedures. We want to get rid of all these procedures at once, but they looked in the codes and they said, we don't have a solution. So then they took the hand of the DES association, and together they went to the Ministry of Justice in the Netherlands, and they said, give us something. Give us a mechanism, a tool to resolve that issue. And that's how the Dutch Collective Settlement Act was created. A second source of inspiration was what happened in the US regarding damages class action. I think Rhonda already mentioned that once a damages class action is certified, then in 95% of the cases, these class actions are settled outside of the court. Well, the Dutch legislator said, that's interesting. Let's take that as the outset, a starting point of our system. So that's how they created the Dutch Collective Settlement Act. And what does it entail? You have an association, a foundation, again, that represents the victims. And again, that association has to be representative enough. And they will start negotiations with the party that is willing to pay the damage. Never say, if one of my students says that, then he's flunked. Never say the liable party. The party that wants to pay, or the insurance company that wants to pay. Because the whole process is not to establish liability. So it's the party who wants to pay, who wants to get rid of potential litigation. So they negotiate. They conclude a collective settlement, an agreement, and then they go to the court. There's one court that is competent in the Netherlands to approve those settlements, and that's the Court of Appeal in Amsterdam. Now, when I explain that system outside of the Netherlands, then everybody says, well, you have to have a settlement, and if there is no settlement, there is no alternative. True. There are actually Well, the first thing is that you have to see that procedure in light of the collective action. Because some of those cases that were brought under the Dutch Collective Settlement Act started with a collective action, where an association sued a company, wanted to have a decision, a liability decision, and then with that liability decision, they went to that company and said, look, we're going to have a collective settlement. So that's the first tool. 2 years ago, the act was amended, and 2 new tools were added. The first tool is called a pre-procedural appearance of the parties. If parties negotiate and they see this is not going to work, then they can go to the court, a different court, not the court in Amsterdam, and they can ask the court, the judge, help us to reach a settlement. And then the court can reconcile the parties, listen to the parties, steer them a little bit. In some cases, he or she can appoint a mediator. That's a first tool to help the parties to establish a settlement. A third tool, second tool, is what is called a prejudicial question. In Europe, we have that system that is called prejudicial question. For example, when a court in Europe is confronted with an issue that deals with European law, then the court can ask a prejudicial question to the Court of Justice of the European Union. The Court of Justice of the European Union will issue a decision, and then the case goes back and the case can go on. Well, in the Netherlands, they also adopted that system. So it is possible for a court, if he or she is confronted with a mass case and parties are trying to reach a collective settlement, to ask a prejudicial question to the Supreme Court about a specific issue of law. Then the Supreme Court will give them an answer, and in light of that answer, the case can go on. So the idea actually is that the judge does not act as an adjudicator, but can also act as a facilitator to help facilitating the parties to go to a collective settlement. Now, the procedure itself, there is no certification procedure. Now, another thing I have to emphasize is that that collective agreement, that collective settlement, is based on a damage scheduling approach. So it contains a matrix, a bunch of parameters, and based on these parameters, class members, group members can be allocated to a specific subgroup. So you have to look in the matrix to which subgroup you belong, and then you can see I get 1,000 euros, I get 5,000 euros. So it's based on that. Now, another reason why they implemented that in the Netherlands, but maybe I will keep that for the conclusion. So there's no certification phase. So the parties, they go to the court once they have reached a collective settlement, and then that settlement is published in the newspaper. There is also individual notice, so the Eisen doctrine from the US applies. So there has to be individual notice to all known damaged parties. And then there's a hearing about that settlement, and everybody who is interested can come to that hearing. You can have objectors, and ultimately the court will decide. Now, once again, and the Belgian legislator copied that from the Dutch, the approval is not pro forma. Again, the court will look into the details of the settlement. Now, you have to see that before you, and I think it was already mentioned this morning, these parties are standing there not with knives, they're standing there hand in hand, kissing each other, saying, "Judge, please approve our collective settlement." So for the judge, it's very difficult to see if there are specific problems, if the interests of the absent class members are safeguarded. It's also difficult because European judges are not used of going into details of settlements. For example, in Belgium, in the Netherlands, if there is an individual case and there's no violation of public policy, the judge will just say, "Okay, fine, go away, clear my docket." Here it asks quite a lot from these judges in the Amsterdam Court of Appeal. So once the court has approved the settlement, so if they don't approve of the settlement, they can ask the parties to go back to the negotiation table and say, "You have to amend this, this, and this. We don't like that. We think that the damages for the class members is not reasonable. You have to change that." But once it is published, or once it is approved, then again it is published, and then there is an opt-out period. Everybody who doesn't like the terms of the collective settlement can opt out, and that person will not be bound by the res judicata effect of that decision, and that person can then bring his or her individual claim. Now, how many cases were brought? Well, the Act entered into force 2005. To date, 6 or 7 cases have been brought. First one was the DES case, a product liability case. So it was actually conceived, created to deal with those personal liability cases. All the other cases, ladies and gentlemen, were securities cases and were financial cases. Also, there's one bankruptcy case. I think the Chief Justice mentioned that, I think rightfully this morning, that these procedures can play a key role in bankruptcy proceedings. Well, the Act was also amended 2 years ago to use that Dutch Collective Settlements Act in bankruptcy cases. 2 cases are very interesting, and Astrid will probably say more about that in another panel. That's the Shell case and the Converium case. Because it dealt with foreign plaintiffs. Most of the plaintiffs were not from the Netherlands. The Converium case, for example, was an investor's claim against a Swiss company. There was a class action in the US, and the federal judge in the US said regarding the foreign plaintiffs, the foreign class members, forum non-convenience, non-US investors, you are not welcome here, you have to sue somewhere else. Remember the Morrison decision and the F-cubed class actions in 2010. So what happened then? The American lawyers called their Dutch colleagues and said, let's create a foundation. Let's create an association to defend the interests of all the non-US investors, and then we will use the Dutch Collective Settlement Act procedure. Everybody thought that that was going to fail, because I think there were 5,000 or 6,000 class members. Only 200 were Dutch. So everybody said, well, the court will probably say they don't have jurisdiction. Something very funny happened. During the hearing, nobody mentioned the jurisdiction issue. So the judges deliberated on the case and they said, that's kind of strange. We're going to issue a first decision and we're going to say that we have jurisdiction based on Article 5 and 6 of the previous Brussels I regulation. And they will say to the parties, look, we think we have jurisdiction, but you didn't brought up any other arguments regarding the jurisdiction issue. So if you want, you can give us arguments to say that we are wrong. It's the first time that I saw a decision like that. Nobody of the parties, nobody of the objectors said anything. And in the end, the settlement was approved. The complete settlement, because there was also, because I told you in the beginning, US lawyers were involved in that settlement. The US lawyers, contrary to the Dutch lawyers, claimed a contingency fee of 10%. The Amsterdam court said, okay, you did a lot of work, you get that. Now, years later, there was a conference. Yes. Years later, there was a conference in Amsterdam, a very interesting conference, and in the beginning of the conference, a very little man came on stage, and he came with his bike, and he was the president of that chamber that issued that decision. And I think there were 200 people there, and there he literally said that that Converium decision is a political decision. Is a decision that they took because they said the alternative for these non-US investors is nothing, because most of them will not individually litigate because it costs too much. So we, Court of Appeal of Amsterdam, said we will help these people and we will say that we will have international jurisdiction. And the president also said that, well, now all the problems of the world regarding mass problems that cannot be solved by US class actions, well, everybody can come to Amsterdam to solve their problems. That was actually the philosophy, and I was quite struck by that statement. To conclude, is that the Dutch Collective Settlements Act a success? The general perception is yes. Willem has published a paper which is on the website saying that it's an expert product beyond tulips and cheese, it's called. I sometimes have my doubts. I mean, the act has been in force now for 10 years. 7 cases has been brought, only regarding securities cases. The procedures take quite long, and if you look at those cases and those collective settlements that were reached, the intermediary costs are pretty high. Another problem that rises now since the Shell and the Converium decisions, where the court claimed international jurisdiction, is the representativeness of those associations. I mean, if you have an association that says we represent the interests of all the investors in and outside of the Netherlands, I mean, I think that's very difficult to get. And finally, I mean, only securities cases, not small consumer cases, because in the Netherlands, and I think Chris will talk about that tomorrow, in the Netherlands they have a fantastic consumer redress scheme, ADR scheme, for small consumer disputes. So, I mean, and these cases or these disputes can be much easily settled through that ADR entity than through that Dutch Collective Settlements Act. Okay, thank you so much.
Thank you, Stefan. We got 2 for 1. By the way, I recommend that you go on preparing your lectures on airplanes. It works beautifully. Our second speaker this afternoon is Professor Astrid Stadler. Professor Stadler is a senior professor in the University of Constance in Germany. She specializes in private law, civil procedure, private international law, and comparative law. She also held in recent years a part-time position in Erasmus University in Rotterdam, where she dealt with comparative mass litigation. She will review the existing mechanisms of collective redress in German law and describe the reform plans of the German Federal Ministry of Justice. Astrid, please.
Yeah. Good afternoon, everybody. Thank you very much for the kind introduction. I'm also happy to be part of this conference, and I would like to thank the organizers and the sponsors for the invitation to come here to Haifa. It's a pleasure for me now to present to you the German perspective, and you will realize soon that it is a completely different perspective from what we heard right now from other member states in the European Union. Well, this is my home university, so you can see it's beautifully located at the Swiss border in the very southern part of Germany at the Lake of Constance. So, well, the European Commission's recommendation has already been mentioned several times. I have to admit, most academics in Europe who were involved in the reform process and in the debate were rather disappointed when this recommendation was published, because it is only soft law, it is not legally binding, and it will not help to develop a uniform instrument for mass litigation in Europe. Chris has also mentioned this morning that not a single government in Europe has followed the recommendation completely, but at least some of the member states have made some efforts to improve their collective redress system. The period for implementation has expired already in July this year, and well, the question is, what happened in Germany? Almost nothing. So there is no groundbreaking news from the German collective redress landscape. There were some efforts in June 2013, so almost at the same time when the Commission published its recommendation. The Green Party, which is not part of our government, they are in the minority in Parliament, they submitted a draft for a act on group proceedings, like a class action, but based on an opt-in system. But it was rejected a few weeks ago because it did not find a majority. In September 2015, our Federal Ministry of Justice announced that they will publish a proposal for a representative consumer action in spring 2016. It's not going to be a group or class action. It will allow consumer associations to sue for a declaratory judgment, not for the compensation of consumers. So they will probably, we are not familiar with the details, and I assume that even our ministry does not know the details yet. It will only be a decision on the liability of the defendant, and then it will be up to consumers to register. There should be a sort of online registration in order to get compensation. Well, this is not the end of my presentation. It would be too brief, so there is at least something in Germany, and I will give you a short overview of the instruments we do have on collective redress in German law. Well, for many years we have the possibility for consumer associations and other legal entities, trade associations, to apply for injunctive relief in case of violation of unfair competition law, on the rules of unfair general contract terms, and also for the violation of consumer rights. This works quite well in Germany. Our consumer associations are very active in this respect, well, always depending on their financial resources, but they do what they can, and we have a lot of decisions and injunctive relief. There is also another possibility for consumer associations, which can be called test case proceedings. It is part of our civil procedure code. It was enacted in 2002 already. But it is an instrument which is based on the individual assignment of claims by consumers. So it's necessary to have either an assignment or a power of attorney given by an individual consumer to the association. And once there is a test case decision, it has no legally binding effect for other consumers. Of course, once the case goes up to the Federal High Court, de facto, the lower courts will follow this decision, but it's not legally binding. So it allows not only test case proceedings, but to some extent also the collection of claims. But you can imagine easily that it has only a very limited scope of application, because consumer associations have to collect claims. They have to address consumers and ask them to assign claims. And this can be done only in small cases, let's say up to 100 and 200 consumers. But it has a limited scope of application, and it will not apply, and it's not manageable to do that in the real big cases. A third instrument we have under German law is called, again, a representative action to be brought by consumer associations. It's an action for skimming off illegally gained profits, or disgorgement, as it is called in the United States. It has been implemented in 2005. And again, it does not offer compensation for consumers. The goal of the instrument is to have a deterrent effect on the behavior of companies and businesses. And you can see the question mark. I have my doubts, and I will explain that in a minute, whether it really has this deterrent effect. When it was implemented in 2005, it was a political compromise, because I will come back to that again and again. There was and there still is a strong resistance against anything that looks like US class actions in Germany. And so, therefore, the problem was that what are we going to do with cases where we have a large number of consumers? Each of them have only suffered a minimum suffered only minimum damages. So rational apathy will prevent that individual consumers go to court. And an opt-out class action was not a solution which could be found in Germany. There was no political consensus on that. So we got these skimming off actions, and legal standing is given to public authorities, to designated entities like consumer associations and trade associations. And I brought you one example, Section 10 of our Unfair Competition Act, or Unfair Competition Act says, whoever, while acting with intent, keep that in mind, with intent, uses an illegal commercial practice pursuant to Section 3 or 7, where these practices are described, thereby making a profit to the detriment of numerous consumers or purchasers, can be sued to surrender of such profit to the federal budget by those entitled, and they are described in Section 8. And we have a similar rule in the German Antitrust Act. Well, one of the crucial issues which was debated intensively when this instrument was implemented is who should be entitled to receive the money to be paid by the defendant. Section 10 of the Unfair Commercials Act, it goes to the federal budget. There were other options, of course. Some have proposed to give it to the Consumer Association, who has successfully litigated that case, or to establish at least a state fund, as I learned now that you have that in Israel, a state fund where the money goes to and where the money can be used for further litigation and can support consumers in other litigations. Well, all that was rejected by the policymakers, and now we have the solution that the money goes to the federal budget. Well, again, you can imagine that this is not a very successful instrument. We have very few cases under this Unfair Competition Act, and none case has been reported for antitrust law. The reason is simply that consumer associations do not want to have the procedural risk. The loser pays rule applies, so if they lose the case, they have to reimburse the defendant for all the litigation costs. If they win the case, they have no financial gain. They may have an increase in reputation, but all the money goes to the federal budget. So, and the risk, I have to mention that again, the risk for consumer associations is quite high, because if you remember, you have to prove that the defendant acted intentionally, and this is really a high threshold. So there are only few cases, and consumer associations are reluctant to use this instrument. Well, finally, we have a fourth instrument, which has been mentioned also by Chris this morning, the Capital Market Test Case Proceedings Act, implemented also in 2005, which has gained some reputation in other countries, unfortunately not for its efficiency. It goes back to a famous mass litigation case in Germany, the Telekom case, which started in 2002 and 2003, when approximately 17,000 claimants filed actions against the Deutsche Telekom, one of our largest telecommunication service providers, based on the violation of capital market rules, giving false information when they went public in the late 1990s. And this case revealed that it is very difficult for German courts with the existing instrument to cope with these cases. The judges in the Frankfurt court predicted that it would take them at least 15 years to deal with this litigation unless the legislator helps with a new instrument. And again, there was the debate, the strong resistance. Policymakers did not want to have anything like a class action system. So the Capital Market Test Case Act was enacted. It is a pilot project, and its scope of application is limited to security cases, so only shareholders can file actions under this act. It had a sunset clause which has been changed several times, and now I think it will apply until 2022, and then we will have to decide whether it will become a horizontal instrument or whatever. It is no group or class action. It is based on the idea of test case proceedings with a legally binding effect for all other cases pending. The proceedings are rather complicated and complex. There was an evaluation of the instrument in 2010, and it clearly said it is not a successful instrument. It does not help to handle these complex cases in a more efficient way or in a more speedy way. There was a reform in 2012, but it was only some minor changes. The basic idea that it should be based on test case proceedings and not become a real group or class action still prevails. Well, the basic structure, the idea behind the whole thing is, of course, the same as behind class actions. Issues of fact or law that are common to a large number of cases should be decided only once and with a binding effect for all the other claimants. So in this instrument, the Court of Appeal will select a test case, decide the test case, and all the other cases will be suspended during this phase of the proceedings. And once the Court of Appeal has given the test case decision, then all the other cases will be resumed and will be decided on the basis of the test case decision. Another option, of course, would be a settlement. If the defendant loses the test case, then it will be a better option to have a settlement with all the claimants. Well, in order to show you how complex this instrument is, you can have this test case proceeding only once you have individual actions. So individual shareholders must file actions. They must decide to go to court and start litigation. And only if you have an application of the parties to have such a test case proceeding, and at least 10 of the claimants join this application, then test case proceedings can take place. So the court has not the right to do that ex officio. It's always the initiative of the parties, and claimants sometimes are very reluctant to apply for these proceedings because it's not very attractive for lawyers. So once we have this application and we have 10 applicants who'd like to have these test case proceedings, in a second step, the lower courts must identify the common issues of fact or law, which have to be decided for all the cases pending, and they have to make a reference to the Court of Appeals. Then the Court of Appeals will conduct this intermediate proceedings, select a test case, and all other cases will be suspended automatically. Well, as the result of this intermediate proceeding will have a legally binding effect on all the claimants, the constitutional right to be heard for all the other claimants has to be taken in consideration. And therefore, all the other claimants have the right to more or less participate in this test case proceedings. They are allowed to file motions, to submit pleadings, and to attend the hearing, the trial. So they are more or less, they are not parties, but they have more or less all the rights a party to the litigation has. The Court of Appeal will make a decision on the selected issues. There is a chance to have an appeal to the Federal Supreme Court. And finally, at one stage, we will have a final decision in this test case proceeding. And then this has a binding effect for all the other claimants. The lower courts will resume the litigation there unless there is a settlement of the whole litigation. Well, what happened to the telecom case? It's interesting to see what happened to it because it was at the beginning of this test case proceeding. Well, the regional court in Frankfurt, soon after the new instrument was enacted, established model case proceedings in July 2006, and they identified more than 33 different issues of fact that were common to all these 17,000 claims. The Court of Appeals in Frankfurt started hearings in April 2008, and finally 4 years later, in May 2012, there was a test case decision by the Court of Appeal, which was in favor of telecom. The Court of Appeal said, well, there was no violation of the capital market rules, there was no false information. There was an appeal by the claimants, of course, and 2 years later again, in December 2014, our Federal High Court confirmed the position of the claimants. So the case has been remitted now to the Court of Appeals in Frankfurt, and it is still pending. And there is no end in sight because this is only the intermediate proceeding. Now the Court of Appeals has to decide again. It will probably go up again to the Federal High Court, and it will take another at least 3 to 5 years until we have a final decision in the test case. So if you remember what the Frankfurt judges predicted in the beginnings, they said it will take us 15 years without a new instrument. Probably it will take them more than 15 years with the new instrument. And it is interesting to keep in mind that the US shareholders of Telecom, they soon filed a class action in the United States, and that was settled in 2005 with a payment of the Telecom, and the case has been settled and finished. So that was definitely much quicker than the German case. Well, we had a number of cases now under this capital market test case proceeding, probably 30 or 40. The latest case under this test case instrument is the VW scandal in October 2015. Shareholders filed a claim in the District Court of Braunschweig because the shares dropped, of course, and there is also already a motion to proceed under this Capital Market Test Case Act. So, well, what are the problems? What are the deficiencies? Why does it not work efficiently? The first point, there is, in the structure of the whole instrument, it is a misconcept because it has to start with individual lawsuits. So from the beginning, it is not a suitable instrument for consumer cases. If you have small damages, no consumer will go to court and file an individual action. It is restricted to security cases, but there was always the idea maybe to extend it one day to make it a horizontal instrument. But with this structure, it's not a suitable instrument for consumer cases. And as I explained, the participation of the interested parties, all the other claimants who have not been selected as a test case plaintiff, is necessary in the intermediate proceedings before the Court of Appeal. Even this intermediate proceeding is still very complex. The original idea was to reduce the complexity to a two-party litigation, at least for this test case. But this does not work. If all the other claimants use their rights and if they do participate, then we have only moved the complexity from the lower courts to the level of the Court of Appeal, and it is still a mass litigation which is difficult to handle for the courts. Well, there was a reform, as I already mentioned, in 2012 with some minor changes of a technical nature. One improvement has been implemented with this reform. The original Capital Market Test Case Act in 2005 did not allow a settlement of the whole litigation during this intermediate procedure. Why not? Well, the idea was this is a test case and we need a court decision, a legally binding court decision for all the other cases, so no settlement should take place at this stage. There was an exception. The Act said, well, if all claimants involved agree to the settlement, then we can have a settlement before the Court of Appeals. But imagine in the telecom case, it would have required the consent of 17,000 claimants, so this was not a realistic option. This has been changed now since the reform in 2012. Now the test case plaintiff is more or less a representative of all the other claimants, and he's allowed to negotiate a settlement with the defendant. It must be submitted to the court. The court must approve of the settlement, and then we have an opt-out proceeding, which is similar to the Dutch Wacom. The settlement will be published. It will be given to all the other claimants, and they have the chance to object. They have the chance to opt out, and there is a rule that unless more than 30% of the claimants do opt out, then the settlement becomes binding for everybody. So this is definitely now a small improvement of the Act, because in practice it turned out, despite the fact that it is a test case, defendants sometimes wanted to settle the case, and they did not want to wait till the end of the test case proceedings and settle afterwards, so why not do that before the Court of Appeals? So this is possible now, and you may wonder, I will come back to the question of opt-out and the difficulties involved with opt-out proceedings later. In Germany, there's a strong resistance to US class actions, particularly because of the opt-out mechanism. And you may wonder why now we do have, to some extent, such an opt-out mechanism, at least for these test case proceedings. Well, in this case, it's not a problem, because all the claimants are known to the court. All the claimants have already filed a lawsuit. They are registered, and it's easy to give them notice of the settlement. So it's not a problem of notice giving. It's not a problem of the right to be heard. And in this extraordinary situation, it is possible to apply this opt-out mechanism. So that's the end of my presentation. There is not much news from the German landscape of collective redress. We will have to wait and see what the Ministry of Justice will propose next year, but I'm not too optimistic that it will be an instrument which is really efficient. We still have the resistance against class actions, and a representative action which allows only a declaratory judgment in favor of consumers is not enough, because, again, consumers have to become active to enforce their damages, and an online registration will probably not a sufficient solution to that problem. Thank you very much.
Thank you, Astrid. We started this morning in the US and then moved to Europe, and now it's time to jump to Asia. Our last speaker will be Dr. Matija Đurović. Dr. Đurović is assistant professor in the law school of the City University of Hong Kong. He holds a PhD and LLM degrees from the European University Institute in Florence, Italy. Dr. Đurović was a postdoc research associate at the same European University Institute. He will review class actions models accepted or being discussed in several countries in East and Southeast Asia. Please.
Good afternoon, everyone. Bearing in mind the fact I arrived yesterday, and we'll be talking about Asia, and that I arrived last night from Hong Kong, that means I'm really still strongly affected by jet lag, which means it's justified if I fall asleep during my presentation. However, I'm going to try to be as interesting and as inspiring as possible so that you do not fall asleep. This paper I'm just now going to present is the result of the currently pending research I am performing together with Dean Professor Geraint Holles at the City University of Hong Kong, and it relates about class action. Professor Coles, unfortunately, due to his obligation as the dean, could not come, but he sent his warmest regards to all the conference. And I would also now like to thank, in my name, in the name of the dean, to the organizers, and especially to Ariel and Rabea for organizing everything so well. I know how difficult it is. And for me personally, I always enjoy being in Israel and experiencing wonderful Israeli hospitality. So thank you very much for having invited me. So what will I be talking today? I moved 4 months ago to Asia, and some of the things I was really inspired by, like it was in all newspapers, all the news. One of the things was recent haze in Southeast Asia, where these numerous fires, like covering a large part of Indonesia, were affecting hundreds of millions of people who live not only in Indonesia, but also not only in neighboring countries like Singapore, Malaysia, Brunei, but also countries like Vietnam or even the Philippines, which are so far away. Then there was another interesting case, which is, of course, very actual in all parts of the world, particularly in Europe and in the States, but also in Asia, bearing in mind how proud Asia is of its cars, Korea and Japanese cars. And, of course, the famous Volkswagen and Audi case, again, something that was a lot in the newspapers. And finally, the thing I was the most impressed by in Hong Kong was the fact that numerous shops are specialized only in selling milk powder. And at the airport of Hong Kong, it was written that it is allowed only to take maximum 1 box of milk powder outside of Hong Kong. So I was asked, what is all this about? So what connects all these 3 very interesting factual situations that affect hundreds of thousands of, even sometimes hundreds of millions of people, because in case of Southeast Asia, it was hundreds of millions of people. In case of Volkswagen, dozens of thousands of owners of the cars. In case of milk powder, it's hundreds of thousands of parents and kids. So what connects all these very interesting cases is that there is, or probably there will be some kind of class action related to this kind of, these very interesting and very, very popular events. So far, what has our research shown that we can classify all the jurisdictions in Eastern and Southeastern Asia into 3 categories. First of all, those are the countries and the jurisdictions, territories, which do not recognize any form of class action. And those are Hong Kong, Singapore, Malaysia. And it's very interesting, especially listening today to the Chief Justice talking about Israel and perfect example of like class action as a common law product. What is very interesting to look at the example of Asia is that exactly those common law jurisdictions are those which do not recognize formal class actions. Because just to remind you, in Asia, in this part of the world, common law jurisdictions are Singapore, Brunei, Hong Kong, and Malaysia. A second category includes those countries where class action has been introduced only recently. I'm talking here in particular about Thailand and about Japan. So which means that they have introduced after years of negotiations, but since they're just about to enter into force, or they will enter into force next year, it is very difficult to predict what will be in practice, what will happen in practice. Eventually, the third jurisdiction we came up with are those countries, territories, which actually have recognized some form of class action and where class action has been already existing for some period of time, and which means also ipso facto that we can examine, we can analyze the practical effects, the effects of class action in practice, in reality, and what has occurred as a consequence of introduction of class action into these legal systems. So, to start with, jurisdiction without a class action. First of all, Hong Kong. Of course, I teach there, I come from there. I was very surprised when I went to Hong Kong to realize that, because particularly when we talk about class actions, because both me and Geraint, we are specialized primarily in consumer law, so we look at the class action primarily from consumer law perspective, though also the idea is to cover also from other branches of law. So what was for me very surprised to see is that Hong Kong has one of the least developed systems of consumer protection, much, much less developed than, for instance, China. Very, very interesting an example. And when it comes to Hong Kong is part of this system, one country, two legal systems, because basically it's part of China and it has common defense policy and common foreign policy, but everything else is autonomous competence of Hong Kong, including class action. So in 2012, after again a long period of discussion, very good, very detailed paper was issued together with the proposal of introduction of class action into Hong Kong. That was May 2012, and it was said that Legislative Council would give its opinion about that within the next few months. We are now in November 2015, no news so far. But this proposed model is kind of mixed of opt-out and opt-in systems. Again, what has been emphasized is there is no any kind of contingency fee agreement or no conditional fee agreement allowed, because what is common to all these three jurisdictions, the three types of jurisdiction, those which do not recognize those which have just introduced and those which have introduced some time ago, is all this fear of US class action and fear that it might be misused and might be used as a tool, as an instrument of lawyers to become rich, which is not that bad for some people who are practicing law. However, as I said, like we are now November, entering December, no news, and no one knows when this class action will be adopted. It's still something very, very controversial. Very interestingly, competition law, Hong Kong is now adopting a rather developed system of competition law based on EU model, which will enter into force just in like 2 weeks. However, again, nothing about class action in relation to the damages for breach of the rules of these competition ordinances. When it comes to Singapore, the proposal was published in 2007. However, again, no results, no news since then. But currently, when I was preparing this presentation, I could see numerous newspapers articles where different associations, different group of citizens of Singapore are trying to see and are urging for class action as a means to fight against the consequences of these horrible fires that occurred in Indonesia, and that really affected a lot the life of all citizens of Singapore. And many of them even suffer different kind of damages. For instance, there is this swimming association who is now leading about this class action, saying that they had to cancel their championship, and because of that, there must be compensation for the suffered damages. Eventually, in Malaysia, I could not find any information when it comes to class action. Again, third example of common law jurisdiction in Asia, in this part of Asia. Now, when it comes to the jurisdictions which have recently introduced class action, those are Japan and Thailand. When it comes Japan, that was introduced in 2013 as a result of one of the OECD papers, the one recommendation of the Council on Consumer Dispute Resolution and Redress, which was published in 2007, and which also advocated for introduction in the OECD member states for some kind of collective redress mechanism. And this is why Japan introduced class action also in its legal system. However, it will enter into force only in December 2016, so it's very difficult to predict what kind of effects it will have into practice. What I can say, what are some of the characteristics? It's opt-in mechanism, which is very interesting. Again, something that majority of the models do not follow, so it's opt-in mechanism. Also, only consumer organizations which are qualified are entitled to initiate class actions. And so far, those are only 11 of them which have been as such designated by the government. That is what is very important. And again, they will be allowed to sue for compensation of monetary damages which are suffered as a result of breach primarily of consumer law. As I said, only in a year it will start producing effects. Second example is Thailand, very again interesting example, where class action was enacted in April 2015, but it will enter into force only in the upcoming weeks, in December 2015, through amendment of Civil Procedure Code. And what is again very interesting is again told you, like civil, as again told you, class action is really politically sensitive in this part of the world. So it really took more than a decade after long and complex procedure. But what has been adopted is pretty much this US-style class action, where lawyers again will have the right to attorney's fees, which must not exceed 30% of the judgment. However, again, it's still not known what kind of effects it will have in practice because it's something really, really new. And also, unlike the Japanese example, which is primarily focused on consumer law and consumer protection, this one, in case of Thailand, is much broader. It covers wider areas of law. So not focused only on consumer protection, but also what is very, very important, what is very hot topic in this part of the world, environmental law, environmental protection. Something very, very, very useful and very interesting. Now, when it comes to the countries which have some tradition of class action, where class action has been introduced long enough to be able to follow, to be able a bit at least to assess the effects in practice, those are Taiwan, South Korea, China, and Indonesia. When it comes to Taiwan, I would say that this is probably the jurisdiction where class action has produced the most significant effects in practice. And as you can see, it's always introduced through different types of acts because it's trying to be amended with reality and with what is needed. Because what has been introduced in '94 seemed not to be produced sufficiently good effects in practice. Eventually, it was amended in 2002 and 2003. And when it comes to some interesting examples in practice, the first one was Gigi earthquake in 1999, when companies which constructed certain buildings were suing in class action for the damages by the people whose houses were demolished because they were not constructed in line with requirements for earthquakes which do occur in Taiwan. Second example is currently one of the most popular decisions discussed in Taiwan, that is a self-help association for CA employees suffering from cancer. It was a class action which represented employees of this company which have, also families of the employees who have died, and also employees who have suffered from cancer but recovered as a result of improper disposal of toxic waste, which resulted that this person have suffered from cancer. Eventually, as you can see, the damages were really, really high. So in US dollars, almost $20,000 million. Really, really important. The decision of the first instance court was published in April this year, but there was an appeal by the defendant, and now we are waiting for the decision of the second instance court. Also, recently there was a color dust explosion, which again affected health of many people in Taiwan, and now there is discussion for starting class action, where more than $100 million will be asked as compensation for the suffered damages. We still do not know. This is a case which is just about to be initiated. The second one is very important because there is first instance court decision. South Korea, very interesting example. Class action introduced already in 2005. First case only in 2009, but in total, very, very, very few cases. So nothing particular to be examined and analyzed because of the complicated procedure, and again, which was introduced as a response to the fear that class action model might be too much based on US, so it might be, as they would say, misused. However, very interesting, now case started only in November, that I will follow closely. It's about owners of Volkswagen cars
which initiated class action, 1,536 of them, the lawyers, in the name before Seoul court. But very interestingly, at the same period of time, an American law firm from California started a class action in the name of all these Korean owners of the car before LA court in the United States of America. So it's very interesting to follow what will be the results of this case in practice. China. China, very interestingly, China, together with modification of its economic system at the beginning of 90s, when it became, when we transformed from being a strictly planned economy into being socialist market economy. Also, one of the first legal acts, which was the consequence of changing of this economic system, was passing of the law on consumer protection in 1993, and there was already some kind of possibility of collective redress, but not much effects in practice. Eventually, the new consumer law, which entered into practice, which entered into force last year on 15th of March, is aimed to reinforce class action mechanism in China. Some interesting cases, as I told you, this tainted milk case, very, very interesting. 2008, what happened is that hundreds of thousands of children were affected by toxic substance which was added to the milk powder. So many hundreds of children died. Hundreds were like thousands had serious health complications, and many children had also some less serious health complications. So this was an action which was filed in the name of the parents of those children. Highly, very political case. And just to tell you how a little amount the company, one of these producers of milk powder, offered to the families whose babies died, they offered only $30,000 US. To those who have serious medical issues, for instance, a lot of kids had kidney diseases, it's only $4,000. And for those with less serious medical issues, it's only $300 US. And what is very interesting, all this occurred 2008, 2009, very political case. So it's still, people do not believe that now there is very strict control about milk powder, but they come still in Hong Kong to buy milk powder for their kids. Again, then a shipping pollution case where, again, factory was causing, due to its toxic waste, serious health consequences of people living nearby. Eventually, there was a class action, and the court said there was no any kind of compensation for damages, but only issued an injunction in which it prohibited to the factory to anymore dispose with toxic waste in such a manner to affect the health of the citizens living nearby. Eventually, another example, all of these were really followed by the media, very strong influence of the media, very interesting. How media played an important role for these cases really to produce some effects in practice. And eventually, telecom case where, again, because of certain problems with telecommunication, with certain problem with the SIM cards, a group of, in the name of the group of consumers, there was a class action, and this was the first case when the court ordered compensation for the suffered damages. Eventually, the fourth jurisdiction which we have examined where there is some form of class action is Indonesia, where we a country with 18-year-old already tradition of class action, and the cases that exist in practice are primarily related to diverse environmental law issues, like floods in Jakarta, where there was a case against the government because floods were expected, but no warning was issued. So that was the case in which, again, these citizens won. Second one is landslide case in one poor part of Indonesia, where the state company was found to be liable for the landslide, which caused to the damages to the citizens living in nearby villages. And eventually, now there is really a lot of discussion, and also some actions have been taken in order to start the actions against the companies which are responsible for the fires which have caused serious health issues to, as I said, not only to the hundreds of millions of citizens of Indonesia, but also of the countries of the region. All in all, to sum up, I have presented the results of currently pending research in the area of class action in Eastern and Southeastern Asia. And we can see that in some, I always say because not all jurisdictions are countries. For instance, Hong Kong is not a country. It's considered to be a territory. In all this, we can classify them into three categories. The first one would include those where there is no any kind of class actions, though typically class action is being discussed. Second, those where a class action has been recently introduced, like Thailand or Japan, and eventually those which have certain already, though limited tradition with class action, like China, Indonesia, China, Indonesia, and South Korea. And again, very interesting thing for this part of Asia, what we can see is those are common law jurisdictions which do not have class action. This is something very interesting. I was inspired to make this kind of conclusion by the speech of Chief Justice this morning. I would like to thank you very much for your attention, and I'm looking forward to your question. Thank you very much.
Thank you very much, Dr. Djurovic. We'll take questions. Yes, please, Rebecca. Wait a minute, there is a microphone.
I have a question for Matea. I find the presentation and the introduction of the Asian systems very interesting. And I was a bit surprised, actually, to hear that in Japan, there is yet no established regime of class action. And even that is proposed, at least in relation to the consumer movement, is limited to an opt-in, actually, kind of group litigation, if I understood correctly. Yeah. Now, I find this surprising for the simple fact that my knowledge of the Japanese system is such that there aren't actually enough lawyers in this country in terms of the ratio to the population. And also, access to court is physically, access to court is quite unreasonable in many areas where many rural areas where actually there are no courts and no law offices. So actually the opt-in logic does not really work there because people can't really opt in. I mean, their ability to opt in litigation is quite limited, whereas an opt-out system would have served access to justice much better. So I was wondering what your thoughts on this issue are.
Does this work? Hopefully, yeah. Thank you, Robert, for your question and very interesting observation. Well, one of the things that really attracts me, I've been only for 4 months so far in Asia, but one of the things I really enjoy studying is Asian legal culture. And that is something also Asian culture being quite interesting when it comes to litigation and to the processes. Because in general, they don't like to go before the courts. That is the general idea. So everything, like it's in general with their mentality, with their philosophy, it's something really not to be used. When it comes to this opt-in, I think in a way you have a point, but I think they're always just scared. Like in any jurisdiction, that's something that really connects all of them, despite the fact whether they do not have it, they have just introduced it, or they have already a tradition, they're always afraid that class action might be used as a tool which may be misused by lawyers. So that effects of it, it's not like to achieve justice, but effects of it, and to compensate the people who have really suffered, but it's for lawyers to get the money. So I think that opt-in is a model which is, in a way, in that setting, the one which seems to be a more like just one, where actually no one can take your action in your name that you do not know about it. So in the sense is you need to join it. You need to explicitly to join that. Just in order, I think that what I was really impressed how much they are all scared of this. Also, that's why in Hong Kong, all the newspapers, I think that was why we do not talk anymore about class action in Hong Kong because it was so much in the newspapers. Thank you.
Thank you, Rabia. I was wondering, how are they addressing the Fukushima disaster? Do they have any sort of mechanism, collective mechanism, for those damages that must have affected so many people?
To be honest, that's a very good point because, as I said, like in this part of Asia, like environmental issues are really, really important, and much, much more important than I would say in other parts of the world because things that happen, and it's in a way to, when it comes to Fukushima concretely, I did not find anything. How this was addressed. I know there are some papers on that, but that's what I still plan to read to see how this was addressed. But this is a really, really good point.
I was wondering if they don't have that culture of litigation, maybe it's something that the government is taking care of, redress and compensation when there is such a natural disaster or a nuclear disaster, like in this case. I was wondering maybe they have some sort of governmental mechanism for redress.
I'm sure that there was something, and I know, for example, in Canada there was paper written about it. I haven't not yet discussed that, but that's a good point. That's an interesting question, and of course that's something I will definitely have a look at. Thank you.
Thank you.
Any other? I would like to ask Stefan, other alternatives in Belgium besides the class actions that intended to achieve public enforcement?
Well, we had a discussion this morning about private versus public enforcement. These class action regimes I was talking about are, of course, an example of private enforcement. But Belgium and France are also very interesting regarding a specific way of public enforcement. In the sense, if you look at the cases, mass cases of the last 10, 15 years in Belgium and in France, you will see that most of them, not all of them, but the majority of them are criminal cases. So in which 1, 2, 3, 15, the company itself, people were prosecuted before a criminal court. Now, Belgium and France have a mechanism in which victims of a crime can bring their civil claim before the criminal judge. Now, in the Netherlands, and I think also in France, that's also possible, but there the criminal judge can say, I'm not going to deal with those civil claims, I'm only going to deal with the criminal aspect of the case, and then you have to go to civil court. In Belgium and France, that's not possible. In Belgium and France, the criminal judge has to deal with the civil claims when he or she establishes criminal liability. Now, that's for the victim very easy because the threshold is very low. The victim, the piggybacking claimant, because it's called in French le mécanisme partie civile, in French piggyback, they don't have to prove anything. They can just rely on the public prosecutor to show everything. When the criminal judge establishes criminal liability, then the criminal judge will deal with the civil claims. Now, of course, if you have a mass case of 10, 15,000 victims, that's of course very difficult. Well, in Belgium, there are some examples. Very creative judges that applied the technique that is now in the class action law. And they said, okay, we're going to establish criminal liability. Now we have to deal with those 10,000 civil claims. We will appoint an expert. And that expert will try and resolve those bulk of civil claims, a bit like you now have in the US with those claim facilitators or in those compensation schemes. Ken Feinberg, for example, these kind of people, and they resolve those cases. And in one case, a gas explosion case, all those civil claims were resolved in 1 year. So that's an alternative, an example of a form of public enforcement that really, I think, has merits. Not a lot of research has been done about that, but that is something that I would like to explore more in the coming years because I really think it has a lot of potential. It's not a perfect system. I think you have to change a bit of the way that these criminal investigations are being conducted. That leads to some problems, but I think there are some solutions to be thought of that can make that system really attractive. And I think it's efficient, it's cheap, because those piggybacking civil claimants also don't need a lawyer. You can do that, you can just write a piece of paper, give it to the judge, these are my damages, and then afterwards the judge will deal with that. So I think that's a beautiful example of a form of public enforcement.
Okay, thank you. You mentioned lawyers, so the last question will be referred to Astrid. And you mentioned, Astrid, that the test case proceedings under the German Capital Market Test Case Act are not attractive for lawyers. Can you explain why?
Yes, the answer is very simple, because lawyers do not have a chance of becoming rich in this situation.
That explains.
Yeah. Wait, maybe I have to explain briefly the German system of lawyers' remuneration. We have a system of legally fixed lawyer fees. And only these lawyer fees, according to the system, the fees depend on the amount in controversy, and only these fees are covered by the loser pays rule. Contingency fee arrangements are normally not allowed. Only under very extraordinary circumstances you can enter a contingency fee arrangement. And the original version of these Test Case Proceedings Act, it said that the lawyer, the representative of the plaintiff who has been selected for this test case proceeding, will not receive any remuneration for conducting the test case proceedings. And as you see from the telecom case, this phase can last for years, and it makes a lot of work for the lawyers. This has been changed a little bit with the reform of 2012. Now lawyers will get a small fee for this test case proceeding, but it's really, from a financial point of view, it's really not attractive. It is a disincentive to be chosen as a model case plaintiff, and therefore lawyers are very reluctant to file a motion to conduct under these proceedings, because they fear that they may be chosen as the model case, and that's something they do not want to be.
Thank you. So we started this morning with greediness, and we are back to lawyers' fees. I just wanted to thank our three excellent speakers. Thank you all for attending, and enjoy the rest of the conference. Thank you.